This is not a complicated case. It's not complicated regulations. It's about official signs. It's about lawful directions. It's about security rules, orders, and directives. And it's about space occupied by an agency. So 2 counts. Count 1's noncompliance with official signs or lawful directions. The government must prove first either that there were official signs posted, or second that federal authorized individuals gave lawful directions, and second that the defendant didn't comply. The official signs, Commander Wiles said that they were official signs. They weren't developed by this field office. They were from Social Security Administration. You saw the text of them that clearly prohibited this conduct. You saw multiple officers, multiple federal authorized individuals, either FPS employees, Federal Protective Service employees, or those contractors for the Federal Protective Service, which Commander Wiles testified were also federal authorized individuals, give those lawful directions. And Mr. Cordova didn't comply.
Here I go, guys.
Great.
We're going to arrest you now. Ready?
There we go.
There we go, man. You're now under arrest. You're now under arrest. They're arrested.
Brings us to count 2, unlawful photography. The elements are that first, the government must show that the defendant took photographs, that either security regulations, rules, orders, or directives prohibited photography, that the photographs were of space occupied by an agency. It doesn't have to be standing in the space, it just has to be of space occupied by an agency, that there were non-commercial purposes, and that the defendant didn't have permission. He took photographs. He posted photographs in the form of a 3.5-hour YouTube clip. We saw many videos from that, many clips from that video. So he took photographs. Security regulations, rules, orders, or directives prohibited photography. There is a rule. The rule very clearly has a warning sign and with exclamation points and triangles in top. Photography and videography prohibited. The defense counsel made a lot of the argument that it's not a factual, but whether the reports knew it was a security sign or not. Ultimately, the people testified were Federal Protective Service employees, and they didn't know at the time. Whether that's in the reports doesn't really matter. What Commander Wiles testified today is it was a security sign, and he followed up and found that out. There were orders.
This is the time and place to argue it. I'm telling you right now that I am not going to allow you to film beyond this door. I'm already allowing you to film beyond that door.
And there were directives. Mr. Cordova calls it a directive.
We asked you to leave. You did not wish to.
So you're asking me to leave?
I did.
Politely? Okay. I'm asking you to give me $5. Can you give me $5? Because I have this policy. I have my own policy that everyone I talk to has to give me $5 that gives me unlawful directives. So.
An unlawful directive. And the space was occupied by the agency. You see the kiosk. You see the customers meeting with agency officials. You see agency chairs, agency signs, agency pamphlets. It was clearly space occupied by an agency.
Of course, we understand that even a lobby is a space controlled by the agency. So Craig Fansler lists off a whole bunch of items as though that proves that it's a space occupied by the agency. But the things he listed, agency chairs, agency signs, agency pamphlets, are all things in which you would find in a lobby.
So the government submits it's proven its case beyond a reasonable doubt on both counts, and the court should find the defendant, Mr. Cordova, guilty of both counts.
So I'm going to do something rare here and agree with the prosecution regarding the interpretation of this rule. There are 3 purposes under which this second charge, 41 CFR 10274.420, applies. There are the commercial purposes of an individual, there are the non-commercial purposes of the individual, and there are the news purposes of an individual. Okay? And there is not the sense of these spaces are occupied and these spaces aren't occupied.
You know, wait, hold on. I think I may be misreading that. So it is photographing for a commercial purpose or photographing for a non-commercial purpose. It's not whether the tenant is using it for a commercial purpose or non-commercial.
That's my reading.
I would agree with that reading, Your Honor. And I think he
drafted poorly.
That's all, folks.
The space. It ought to say may take photographs for commercial purposes if, for non-commercial purposes if, and of building entrances. But now I see what you're saying and I agree with you. Okay, go ahead.
Okay. And that means that that third section, for news purposes, is distinct and different. And the idea that the distinction between A and B and C is whether the tenant agency is occupying the area or not, that's not a correct reading of this statute. Auditoriums, are those just free-floating spaces that nobody owns? Of course they're occupied by the tenant. All of these spaces are occupied by the tenant, including a lobby. A lobby is not a free-floating space that nobody owns and nobody manages and nobody has rights over and nobody locks the doors.
And you can't spend the night there either, probably.
I would presume that you can't spend the night. And in fact, they even talk about that being a foyer and that they lock the front doors outside. I assume that no one can sleep in that space, in that vestibule. So the distinction is not this was a tenant-occupied space, so therefore 3 doesn't apply. The question instead is, was this an entrance, lobby, foyer, corridor, or auditorium? And those are all distinct and different spaces. Certainly a corridor is something to be like a hallway, which is not a building entrance. And as I've made this argument multiple times, a lobby is different than a foyer. A foyer is where you walk into. When you first walk in, maybe that's where you take your coat off. A lobby is where you wait. A lobby is a public space where you wait to be served. And at the very least, both for the purposes of whether the people have proved beyond a reasonable doubt, but also for the purposes of ambiguity under the First Amendment. And the First Amendment is absolutely called into question here because this was photography. The 10th Circuit recently in Yahia observed and recognized a First Amendment right to film public operations. Now, obviously, that makes it subject to further, forum, non-forum. And if you'd like, I can give you a cite for Yahia v. Irizarry. I was on that case.
I know Mr. Irizarry and Mr. Brandt very well.
Yep.
So let me ask you this.
Sure.
So from a textual standpoint, A, B, and C are distinct.
Yes.
And C attempts to distinguish a space from that identified in A and B. You agree with that?
Yes.
So what is the difference we have to ask, right? And you're saying it's so vague it doesn't give somebody notice? Is that what you're arguing?
I believe that there is an element to that, yes. If the fact that one of the police officers himself described this space as a lobby and another doesn't, that goes to showing this ambiguity. And it would be reasonable.
One says foyer?
One refers to as a waiting room.
Okay.
If you review the two, in fact, if you were to review all of those, I know they weren't admitted, but in Exhibit 12, every single person, the other people refer to it as a waiting space or a waiting room.
The space he was in first for most of the time?
No, the later space.
Okay.
It's never referred to as the offices. It's referred to as a waiting space, as a lobby. But whether it was...
Wait, who refers to it as a lobby? And where do they do that?
Officer Ramos, I believe.
The space beyond the second set of glass doors.
Yes, yes. I'll turn your attention to Exhibit 12. And upon arrival, we entered through the foyer and into the lobby. Later, he advises the individuals were advised by the on-duty PSO that they were not allowed to film in the lobby of the SSA.
But are you aware of the word lobby being used in any of those videos? And I assume
I'm not aware of that.
Are you aware of the word lobby being used in any of those videos?
I am aware of a clip I did not play where Commander Wiles actually explains why he does not consider it a lobby.
And I'm not familiar with that
Very
clip,
good.
but regardless,
No, not regardless.
Sure.
If he had called it a lobby to Mr. Cordova's face,
Yeah,
that next space,
sure.
that could be a problem for the government.
Inside the lobby here? Does
This
it
is
say
not
we can
a lobby.
film inside the lobby? Oh, this is not a lobby?
A foyer. This is not a lobby.
Oh, what is this then?
This is a waiting area. This is a waiting area. This is a waiting area where there's PII
It's a lobby.
being
It's
divulged.
a lobby. It says clear as day in the lobby. We can film.
If one of the officers had called it a lobby, that could be a problem for the government, says Magistrate Hegarty. Well, good thing he's safe there because he, in fact, did not call it a lobby. He called it a waiting area, just as Magistrate Judge Hegarty said people were in chairs waiting their turn. And where do you guys think people wait their turn? Well, I could throw a wild guess out there and say a waiting area. And just as I said in the beginning of this video, and as my attorney said, Synonyms for a waiting area include lobby. Would you look at that? Isn't that amazing? So, do you see the deception going on here? Do you guys see the lengths that they'll go through to not be held accountable? That could be a big problem for the government, he said. But he didn't say lobby, he said waiting area. So they are going to stand by that I should be locked in a cage for 15 days, actually 16 days, because it's not a lobby, it's a waiting area. They want to lock me in a cage over semantics. This is just absolutely disgusting, guys. I am completely appalled.
Of course, that would...
Because the word lobby is explicitly used in a regulation as a place you can photograph.
And I understand. Of course, that would be better for me. Of course. I would say that would categorically make it so that this was a lobby. What I'm saying is instead, it is not categorically not a lobby. And they have a burden of proof here, that it is beyond a reasonable doubt that that was not a lobby. And here is one of these two officers, arresting officers, calling it a lobby. But also for the purposes of the First Amendment, there's the question of vagueness. That we should not be subject to criminal sanction for otherwise protected activity unless it is definite. And if one of the arresting officers calls this a lobby, I don't know how that's not vague.
You're arguing that where your client ultimately was a 74.420C space.
Correct.
And if it's not, then the statute is vague. That's what you're saying.
Correct.
All right.
My primary is that he was protected by this. The secondary would be they haven't proven, actually, there's a second in between those two, that they haven't proven beyond a reasonable doubt that this was a lobby, and I suppose that's kind of a subsection of that first argument. And then the third would be that if it is determined that this was not a lobby, that this is not within that space in C, then it's at least vague to the degree that it does not provide.
But does proving beyond a reasonable doubt analysis even apply to a court's legal decision about what a space is and whether a statute is constitutional or not? Because proof of a reasonable doubt is what factually occurred.
Sure, and I believe that one of the elements here must be that he was not performing news services or news activity for news purposes in a building entrance, lobby, foyer, corridor, or auditorium. That is an element. And I believe that that element needs to be proven beyond a reasonable doubt, too. That they must prove beyond a reasonable doubt that, all three, A, B, and C. Now, we're not contesting A and B. He did not have permission. So it really relies on C, but they have to prove C beyond a reasonable doubt. And to prove that, they must prove that he was not performing news services or that he was performing news services but was not doing so in a building entrance, lobby, foyer, corridor, or auditorium. And that proof, that element must be met beyond a reasonable doubt. I believe at this point that the United States has not proven beyond a reasonable doubt that this was not a lobby space. They've introduced testimony of one individual who does not work there, who does not frequent that space, but we do have evidence where there is some understanding of this space by these federal officials that it was a lobby. Turning then, these regulations, these signs that they've posted, they're not security regulations. You have the job of making that determination, but we've heard over and over, this is for privacy purposes. Those are maybe important policy considerations, but they're not security purposes.
How are you viewing the word security in this context?
I believe that that is akin to you can't record security officers, the ways in which we secure the building. If we were to say security means securing people's personal information, I don't know. I worry that we could say we're securing people's ability to eat lunch. And so no filming in public courtyards. We are securing, it would stress the word security beyond anything if it goes beyond what is actually securing the building. And if that were to be...
Have you been to the National Archives?
Not in many years.
Have you seen the U.S. Constitution? Or the Declaration?
No, I've never seen that while I was
walk
there.
in and see the original, and it's behind a very thick piece of glass.
Sure.
You can stand there and look at it.
Yeah.
Would you call that piece of glass a security device for that document?
I think that's arguably, yes, a security device.
For the purpose of securing a piece of paper?
Correct.
So security can refer to both the security of a person and security of property.
Sure.
You agree?
Yes.
So anything in there that's intended to secure both information, paper, property, and persons could be reasonably viewed as security.
I would agree, but again, we're talking about now protecting, not securing. And those are two different terms. Protecting people's privacy rights is different than securing, security of the Constitution from theft.
No, I'm not so sure. So you see that kiosk that had the two sides where somebody standing next to it couldn't see what the person is doing?
Yes.
That's a security device for making sure someone over here can't see what somebody's entering on a computer. Would you agree?
No. I would submit that that's a privacy device. They weren't trying to secure people from harm, and they weren't trying to secure documents from theft.
Well, theft can be both physically taking and actually, I mean, when identity theft occurs, no one's physically taking anything.
Sure.
They are taking information and using it in an improper way. That's still theft, correct?
Yes, I think we're torturing this definition of security beyond.
This is apples to oranges, because if I was hacking a database, stealing documents, deceiving someone into obtaining their social security number, buying numbers on the dark web, or impersonating someone to get their social security number, then that would fall under identity theft statutes, fraud statutes, computer crime laws, wire fraud, and identity fraud. But simply taking pictures in a public space in which I have the right to do is not by itself illegal. Again, Judge Hegarty, aka the government, is shifting the blame onto me instead of taking accountability for forcing you to conduct business in a public lobby. And yes, I still stand by, this is a lobby.
You know, I worry if all of privacy is encompassed within security, then this is a much broader statement. I think personally that...
We're having some fun here.
Yeah.
Do you have any problem, would your client have any problem with a U.S. government drone flying over his property that has one of those cameras so good you can see from outer space and videoing everything that he's doing, including through his windows into his house? Do you have any problem with that?
Yes, but that's not a concern of security. That's a concern of privacy under the Fourth Amendment.
Right.
I'm distinguishing. I think that there's a distinction between privacy and security.
Take that same camera and it's looking sideways into somebody's personal information. Any difference?
I'm not saying that there shouldn't be a regulation for privacy. I'm saying that this one doesn't. Plain language is clear here, and it says security. They very well could have written security or privacy.
74.385.
Yes. I'm not speaking to what would be good policy. I'm speaking to what's written. And what's written does not contemplate or discuss privacy concerns. It discusses security, and I think largely what is intended here would be the security line. You know, security cameras, making sure that people aren't breaking into facilities and that we're securing these buildings. This is not what should be, but what is, Your Honor. And what is does not say personal information here. Nobody ever said the word security until they read over the regulations and got into court. There was no discussion. These are for people's personal information, their confidential information. This is for security purposes. So, again, I've seen no proof other than some, I would argue, self-serving testimony that this was a security regulation. We have not seen where this comes from. We have not seen the folders. We have not seen testimony from someone that drafted it, that an administrator at this building that said this is what this is for. We've heard some testimony that this is held somewhere on some database in a security folder. But more to the point, these signs don't specify the purpose. They don't narrow in on security purposes. They just have a general broad prohibition. I will tell you, I did a case law research for security regulation, and essentially every single result that popped up was Homeland Security regulation or Social Security regulation.
So you don't think my research is going to show anything that interprets this particular regulation?
I mean, I doubt it. I doubt it, and I have not seen any interpretation by the Social Security Administration as to what this means. Certainly no evidence has been produced as to how the Social Security Administration interprets the term security regulation. And it would seem problematic to me to interpret it differently at each case whenever they're pursuing a conviction. I think it would need to be ahead of time. But I don't believe that there is such a regulation or interpretation out there. Turning to those signs are not clear that they prohibit his conduct. They say in the offices. I don't believe that this was an office space. This was a large space, but the office would be behind those glass doors. They would be in those hallways. They would be in private spaces. The first one, it says while in the office with these pictures of these cameras. The second one says federal law and SSA policy prohibits taking pictures inside SSA offices. Both of them refer to offices. And offices, plural. Not the office. Not the Social Security office, but offices. right?
Look at Exhibit 3.
Mm-hmm. Okay.
See what the top sign says?
I do. I would say that office hours is a slightly different term of art than office. We're picking at threads here. I will agree.
It's not a thread.
No. What I'm saying is distinguishing different spaces is different. Probably not going to have foyer hours. These are the hours you're allowed in the foyer. But I think it's pretty indisputable that this space that they were in for the 3 hours was a foyer. But I would say that that term refers to the whole space, but offices is a distinct word, or at least is reasonably understood to be a distinct phrase of you don't get to videotape when you're in someone's office, when you're at that space. That's different than when you're in a lobby. And again, ultimately, I fall back on my previous argument that the specific overrules the general. They can issue lots of rules and posters that aren't spoken to elsewhere. But as it relates to photography, 420 is clear. It has to be a security regulation. These, as we've heard, refer to confidentiality and personal information, not security mechanisms. And the last issue I would point out, Your Honor, is I don't know how to tease this out. Believe me, I've thought about it. I don't know what makes a sign official and not. I haven't heard testimony as to who placed this, if this was just a janitor who threw this up, if someone with a printer that didn't want to be photographed threw this up, or if this was an officially, enacted, adopted poster by the person that controls this office. Certainly that person was not here to testify today as to how this poster came to be posted.
Yeah, you're not going to die on that hill, though, probably.
I'm not going to die on that hill, but and the truth is I really don't know how the people would prove that other than bringing someone in to testify. Yes, I did adopt that, but it doesn't say signs of a prohibitory, regulatory, or directory nature, but official signs. And at least I would say the evidence does not support a finding beyond a reasonable doubt that these are official signs. The United States could have brought someone in to speak to how these signs came to be posted. They didn't. That was their choice. But they have an obligation to prove each element beyond a reasonable doubt, and one of those elements is that these signs were indeed official. And I have seen no evidence. Certainly Mr. Wiles does not have that personal knowledge or information. I have nothing further, Your Honor.
Thank you.
Thank you.
Any rebuttal?
I know that we talked about the signs not being the hill to die on. Commander Wiles did talk about them coming from the Central Social Security Administration. And the other thing, I don't think Your Honor even needs that testimony. You have the photos that show the official seal on the bottom, the GSA seal and the SSA seal. It says federal law and SSS policy does this. I mean, the fact that they're official.
It's produced at U.S. taxpayer expense. It actually gives a publication number. It gives an ICN number. Again, he said he's not going to die on that hill.
That's right, yeah.
When did my attorney say that he wasn't going to die on that hill? The judge said, "You're not going to die on that hill, are you?" They're putting words in my attorney's mouth. In fact, my attorney is adamant about how these signs are not official, and he's going to explain that in further detail coming up.
Yeah, I don't have anything beyond that to add that we haven't already.
Okay.
Your Honor, briefly.
You may.
Those numbers, you should Google them.
Okay.
I haven't found anything.
The ICN?
Yeah.
Well, not everything's on the internet. Thankfully.
I would hope that the government regulations are, though.
I'm not even sure what ICN stands for, International something number, but whatever. Okay, so are we considering the case submitted? Okay, we'll be in recess, take the matter under advisement.
Thank you, Your Honor.
Thank you all for your presentation today.
All right.
Okay, so that is the end of season 1, which is the trial, and then season 2 coming up next is going to be the sentencing hearing. And if season 1 of the trial kept your attention, season 2 of the sentencing hearing is going to hit even harder, I promise. My attorney comes in with a lot more passion, his arguments hit harder, and that's also where I personally address the judge right before getting sentenced to 15 days in jail, where I end up spending 16 days. So if this series kept your attention, the sentencing hearing is going to be even better, I guarantee it. Then season 3 is going to be my entire stay in jail. And that's going to be a whole other thing in which I haven't even started on as I'm recording this right now. But I already have season 2 ready to go and lined up, so you can be expecting those to be coming out pretty quickly. Thank you so much for watching this, guys. It really means a lot to me. Namaste.
You don't put your hands on free members of the public unless I commit a crime, and I'm not committing crimes.
Already told you cannot come in.
And I already told you, bud. I already told you.